In the heart of San Francisco, a battle is being waged, not on the streets, but in the courtrooms. This is not just the story of one landlord. It's an expose of a system where political influence can override due process and private property rights can be swept aside. When Ms. Kihagi purchased apartment buildings in the city, she unknowingly stepped into a political crossfire. What followed was a calculated campaign by city officials using questionable legal tactics, biased proceedings, and an altered final judgment to seize her properties. This documentary reveals the alarming abuse of power that led to the forced sale of Ms. Kihagi's assets, sending a chilling message to property owners. In San Francisco, the rules can be changed at any time, but to orchestrate such a heist, a $50 million heist, you need more than just political maneuvering. You need key players, willing and ready to step outside the bounds of the law. This story unveils the hidden network behind the seizure: corrupt judges, complicit prosecutors, and a shadowy figure often overlooked, the receiver. Let's start with the architects of this legal siege, the corrupt judges. These are not always the stereotypical backroom dealmakers. Some are cunning, adept at twisting legal procedures and finding loopholes to avoid applying the law as written. In this case, it began with a highly motivated judge, corrupt Angela Bradstreet, whose activism and the very nature of this case provided immense motivation. We will expose the tricks judges play, including the cynical use of discovery sanctions as a shield to hide their own transgressions. Next, we turn to the city prosecutors, the legal foot soldiers who circumvent state laws, creating new laws on the fly, hoping that most San Francisco landlords will never catch on. These are the individuals who weaponize the legal system, turning it against property owners. Welcome to the world of deputy city attorneys, Michael Weiss and his prior supervisor, City Attorney Dennis Herrera, who hoped to use this case for his political ambitions, which sadly fell apart. And finally, we delve into the world of the receiver, a shadowy figure often overlooked, yet instrumental in the scheme. Receivers are meant to be officers of the court, guardians of due process. But in this case, we expose the shocking truth. A deeply corrupt receiver, instrumental in pulling off this elaborate scheme. This is territory rarely explored, a dark corner of the legal system where abuse thrives. Welcome to the world of the most corrupt receiver, Kevin Singer, and his licensed legal partner, John Rachlin.
In a summary, I think if somebody really asked me without being humorous or without being jovial, who am I would say I'm an amazing real estate designer. I'm very good at what I do. I'm a very good designer. I like beautiful things. I've always appreciated a lot of beauty. Anything I touch, I try to design spaces that bring in a lot of light, a lot of open space. And I like old buildings. And so San Francisco was alluring because of the old character buildings that it has. And I had lived there for a long time. I went to school there and I came back after working on Wall Street, was happy to come back to the Bay Area, sold my condominium, and I needed a building to buy or live in. So instead of being in a condominium with an homeowners association, I decided, why not just buy a building and not have to stress out about a HOA organization, just live in one of the units. And so that's what I did, and that's how I ended up buying my first building. The way I got into the Bay Area was sometime around 2014, 2015. The real estate market in San Francisco was really, really tight. And my poor sister, one of them, lived there, and she was living in Pacific Heights, where she was staying not even in the central part of Pacific Heights, but on the edge, outskirts. We call it Lower Pacific Heights. And she was paying $3,600, and her rent was about to go up to $3,900. And they kept calling to go how difficult it is to find housing. And I thought at the time, I had done pretty well. I owned buildings in Los Angeles, and I thought to myself, my God, what is the purpose of having this if you can't help your own siblings or your own family? So that was a good thought point, and I said to myself, since I lived in San Francisco, had sold my condominium, my sisters were also looking for homes, and I had lived at that time. I was spending more time fixing places in Los Angeles. So I literally liquidated a lot of my buildings in Los Angeles and ended up buying in San Francisco. The other thing that my sisters all gloated about was the Mission. The Mission was the happening place of town. Well, I had actually lived in Russian Hill, which is a little bit more, call it more settled in terms of the buildings, the people who lived there. And the Mission was where a lot of the young techies were coming in and they wanted to live. It was more edgy, it just had so many restaurants. And for me, I realized, having lived in Los Angeles, I speak Spanish. there's a natural affinity to be closer to Latina or people who speak to me in Spanish. I felt more at home being closer to where I could eat Spanish food, run into a few Spanish people. And in San Francisco, it's such an odd thing that a Black woman is speaking in Spanish and you're like, not for Los Angeles. This is nothing unusual. People here speak more than one language and it's important. Well, the reason why that's interesting is the fact that I spoke Spanish became also something that was held against me in that city. When one of our tenants who lived in our buildings, her name was Alison Leshevsky, filed a complaint with the city, she stated in her complaint that the reason why she was filing a complaint was because I had allowed, she called them illegal aliens to live in my building. So my contractors and I were very close. We hang out. We speak fluently in Spanish all the time. Their English is not perfect, so I prefer to, of course, speak Spanish, and that's enhanced my ability to speak Spanish more fluently. And so while they were working with me, because they're the guys that I worked with in Los Angeles, in my crew, I, of course, let them stay with me in one of my buildings. And we would dine together sometimes, or most of the times, at least sometimes of the week. So I want them to be close to me, and I'm the only reason they've come to San Francisco, so why would I not want them to be in my building? So the guys lived in one of my buildings at the time, and this is my building at 195 Eureka. And this tenant, again, Alison Leshevsky, the name will come up because she became one of the big organizers to campaign to the city that I was doing something wrong. So the story really is about City of San Francisco's heist, a $50 million heist from Black landlord, and aptly titled so because it's been theft of my buildings to the tune of $50 million that has been stolen. And my goal in telling the documentary is not just to change the law, is that I'm coming back to get my buildings, and I will get each one of them back, is what I am committed to do, because what has been done is a violation of law and an opportunity to go and right what has been done. The first building I acquired was the one I lived in on 18th Street. I bought it in June 2018. The following month, I bought another building on 19th Street. I paid about $2.5 million for it. Around sometime in August, I bought my beautiful building on Filbert Street, which we're going to be going through it, how gorgeous and beautiful these buildings look. Then in 2014, I continued acquiring buildings, and I acquired a building somewhere around June of 2014. I acquired a building that I absolutely love, located on Hill Street. Hill Street is one block from Valencia, super gorgeous building, and just within a stone throw away also from Dolores Park. Then I also acquired at that time the building on Guerrero Street at 1135 to 1139 Guerrero Street. A traditional Edwardian building, nothing fancy, but beautiful bones, decent, and good space. I mean, it's one of the larger units that you will see in San Francisco. And through the city's actions, those buildings were sold at distressed prices, and I never got a penny out of every one of these buildings. And most owners would buy a building with the intent of moving in, or with the intent of moving their son, or their daughter, or their mother, or their sister. There's nothing illegal about that. It is allowed. It is actually okay to do that, because you have an owner who lives in the building and cares even more for the building. Because when you see an owner living in a place, the buildings tend to be taken care of in much better shape than if you don't have the owner living in the building. In my case, the city had one of the tenants that they claimed that I had displaced to move into, and his name was Kelly Kimball.
I feel like I specialize in real property litigation with the emphasis in rent control in San Francisco. I'm also an active landlord. Yes, it was always the owner's prerogative to choose a vacant unit that's available and doesn't house a protected tenant.
Despite the law being very clear that an owner can choose the unit to move in, Mr. Kimball or tenant Kimball was refusing to move out. So imagine they create the laws, they say you need to pay your relocation fee, and he refuses to move out.
In this case, that particular unit that belonged to Kelly Kimball was not, Kelly Kimball was not a protected tenant. And it seemed to me he was just pulling the same ordinary delay tactics by attacking the pleadings to make Ms. Kiyaki start all over.
In San Francisco, which is a very small city, when one tenant feels that they are at threat of being evicted, or they're doing something that they need to cover up for themselves, sometimes they'll take advantage of that position to say we're organizing other tenants. Well, this is interesting. The organizers, in my case, were mainly two people, the woman by the name of Alison Leshevsky and a tenant by the name of Dale Duncan. Now, why are these two people very concerned about being evicted? In the case of Dale Duncan, he had overheard me talking to a realtor when we were inspecting the building at the time we're buying it, and we said, oh my God, the location, 1 block from Valencia, was ideal for my sister. So he knew one of my family members, I didn't say which one, would be moving into the building. That made him concerned because at the time I think he was paying something like $1,200 in a unit that they claim is worth $4,500. So that's a huge discrepancy from what the true rent is. He also had a front-facing unit, and most owners always want to be on the front. Some of them might want in the back because, of course, people have different preferences, but most people want to see what's going on at the front of their building. So he was very concerned that he would be able to protect that unit, and I think that was an issue that got him organized.
She had two sisters. One was going to pharmacy school at UCSF, and the other one was a chemist and commuting it to the East Bay. And so it made sense since they had no reason to continue staying a tenant if they didn't have to.
When they heard, I don't know how they got together, but maybe as they were calling different organizations, they were got together with Alison Leshevsky. They decided that they were going to organize and create like a tenant group that would fight back against me. Now they're fighting just me. I'm the manager of the limited liability companies, and I'm also acting at the time as the property manager, and I'm good at what I was doing, or doing a good job, the best I can, but I have a lot of disruptions, and I'm also living in the building, so there's a little bit of a sense of fear that's also going on in the background. The reason why this tenant, Alison Leshevsky, becomes important again is because she lives in my building on Eureka Street. She says, because she has a dog, that she walks the dog every day by each one of my buildings. That would scare any landlord, that you're being monitored that much. So every day she would walk around, take pictures of my sister's car, and in fact she was telegraphing to the city attorney, deputy DCA, let's call him deputy city attorney, so I'll use DCA Wise, and Weatherford, and she was informing them that, oh yeah, I keep seeing the car belonging to the sister, and then sometimes I see Ms. Kihagi's car, it's blocking the parking driveway. Now, those facts are very important. So we're blocking our driveway on my building on 18th Street. And why that becomes important is one of the main allegations that was being made was that I evicted tenants with claims that I was going to move in or my family members would move in, and that we did not move in. But yet now, you actually have evidence that's coming from the city's own investigations, as well as the tenants themselves, because now they're organized, they're driving by and monitoring you every day. And they're saying to the city, yes, the car is always there. The key word always means that you're often there, and that's good evidence that you live there. And they're walking around the dog at all kinds of hours, morning and night, means that you are generally living there. So the city's case was not, it starts to fall apart because this evidence detracts from the type of message that they're trying to put out, which is, oh, she displaced tenants, which is legal. There's nothing unlawful. A task force is, I didn't know what that was until sometime in 2015. I'd never heard of anything like that because we don't have anything like that in Los Angeles. But what I learned was that the city, when preparing to try to fight with a landlord, they look for ways to, number one, bring you into line or intimidate you. And so what they create is called a task force, supposedly. And the task force is really in the building code or in the San Francisco code when you're dealing with landlords who might have repairs that are not undertaken and you need them to take care of them. But in this case, the city was actually creating a task force for two reasons. They said, and we're going to go through the actual document, they gave the two reasons and said, they created what they called a task force. They sent a memo to the San Francisco Building Department, and in their memo they told the San Francisco Building Department that the reason why they were creating this task force was because Ms. Kihagi, number one, has evicted long-term tenants and replaced them with market rent tenants. Well, I don't know what that sentence means, but it sounds like you've evicted somebody who's been there and then you've replaced them with market rate tenants. And then number two, they said she is also housing illegal aliens. Key word, illegal aliens. Now the reason I emphasize that is because today, a lot of people are very pretentious and do not want to actually call anybody an illegal alien. They want to change it to undocumented. Yet when they were talking about me in paper, behind the scenes, they call them illegal aliens. So let's not pretend that when they're in their back offices, they're allowed to use certain language. And when you come in front, we try to pretend for society, signaling purposes, that we use words like undocumented. The document speaks for itself, and it's something that we're going to go through. The task force is important is what they do is they say they bring like 7 or 8. In my case, they brought about 8 people, most of them men. One of them was like, for example, an electrical inspector, plumbing inspector, mechanical inspector, building inspector, housing inspector, city attorney Michael Wise, Deputy City Attorney Michael Wise, Deputy City Attorney Victoria Weatherford, and then they had the audacity of even bringing police officers with guns, with guns loaded. So I didn't even know what to expect, but I knew it sounded intimidating, and I told them they were violating my rights, because they did not have a search warrant, and they had not demonstrated to the court that there was any probable cause to want to enter into my building, and I said I will not be allowing any entry. So they spoke outside, they turned to the police officer and they were told, yeah, it sounds like you need a probable warrant. And then they lied to us and said, okay, we're gonna go to court. And so I assumed everything was done. Little did I know that they were running to the next building, and they would run to the next building without me there, and try to enter by telling the tenants that they had permission and they had paperwork and they would go through. So on a hunch, one of the security members that I had hired decided to go to the next building to make sure everything was kosher. But by the time he got there, they were all over the place. He sat there, he recorded it, and during the process of going from one building to another, he found that letter that was written to the building department, in which they gave the real reason and the real motivation why they were doing all these purported inspections into my buildings. So that's how they ended up with what they called task force.
A task force inspection against a slumlord as a way to go and search around someone's private property and try to find code violations, which is not proper under the building code. And so when they were called on that, and Kihagi filed a federal court case against the city, but more particularly, these are the acts of Deputy City Attorney Michael Weiss and Victoria Weatherford. And they're the ones who were in the code enforcement department, not in the rent control department or the tenant rights department. These are just code enforcement people, and they're trying to use this to try to get in, to find ways to just make Kihagi look bad. And meanwhile, the entire time, the Kihagi could be working with the DBI and curing things and paying whatever fines, or renewing permits, or creating new permits that comply with the work if it was beyond the scope of the initial permit application. So all that was done, should have been done at the building inspection department. But because it's so obvious that because Ms. Kihagi filed against Michael Weiss and Victoria Weatherford, and one aggressive building inspector that was running around going into private properties that he had no just cause, no research inspection warrant, nothing. And this is all after they were told by Ms. Kihagi's attorney to back off.
Looking at the timeline, I think it becomes very clear that the city's complaint was always a retaliation against my standing up for my rights and for my standing up against not being pushed over. And this really comes back to what I said in the beginning. This is about a woman whom they saw or viewed as being too black, too female, and too feisty. I was fighting, and they're not used to that. And in fact, the emails and the messages from the city attorney's office, they write and they say to the judge, she just keeps fighting, or she keeps not giving up. So in other words, they thought they would beat me up to a point where you say, this person is so defeated and there's nothing more to do other than simply give up. So that was not what was happening here, or why I have persisted in my fight. It's the fact that I saw city attorney's office, violating so many laws. And not only do they do it once, they do it again and again. And then most people end up, cowering and hiding in a corner and crawling into some corner where they never show up again. So we never really get to see what's really happening behind the scenes.
That press release was to create this odious hate against this person they had just filed a lawsuit against and they had gotten sued by. And so it was all very self-serving. And then they reach out to particular socialist politicians like Scott Wiener, who say, without even knowing anything about Anna Kihagi, she's a sociopath. It's like, what? It's like, and I think the city was probably after their task force inspection when you realize that there's really nothing wrong with the buildings. I mean, how embarrassing would that be? You have a task force inspection and then you can't come up with anything because Anna Kihagi isn't a slumlord. They knew nothing about the education level or anything about this black landlord. All they know that they saw a picture of her, and she has a dark face. And they just thought they could just go take advantage of their powers under their code enforcement to try to create a task force to go find things in her buildings. And when she objected, and then when her tenants that do not want people coming in and doing inspections of their apartments without any probable cause for anything, I think they were a little chagrined. But when they got served with the lawsuit, then 19 days later, the city completely retaliates with this exaggerated complaint against Ms. Kihagi and start issuing self-serving press releases against this black landlord. And they continue to do those press releases for years, just by putting up the pictures of black property owners that evict tenants for financial gain after they fixed up their apartments after they evicted them, which is what white people do all the time.
What the city did was they were not able to get into, for example, my building on 18th Street because I wouldn't let them in. They went to the next building, and in the next building on Eureka Street, the tenant Lishevsky was waiting for them at the door and opened the door and said, "Come on in." So they were able to go through the common areas of the building and also the tenants who allowed them in at the time, which at that time was Alison Lishevsky's unit. So they weren't able to see my tells, but they put together a report. And then after that, they went to the next building. I understand they went to Hill Street. And in Hill Street, we had Dale Duncan, who was an intimidating guy who just talked a lot and had all the other tenants, just around his fingers, manipulated for what he wanted or for what his motive was. In that building, all the tenants were able to let the city go through and inspect each one of their units. So let's talk about Dale Duncan's unit. Dale Duncan's unit, which he had lived there almost for a good, he said at that time, almost a good 17 years. They found torn linoleum about below the fridge, one. They found that there was a missing handrail going on the second floor to the unit. They found that there was a missing smoke detector in the hallway. They found that there was a missing smoke detector in one of the bedrooms. They found that there was a broken glass, which we will go through and we'll show that the tenant admits had existed for a long time, and he said didn't bother him. Whatever these violations were, they're all things that have pre-existed and that these tenants had never called their prior landlords to express any concerns about. But all of a sudden, now they're making it sound like there's something big. And most people not understanding that would assume, wow, there's something big going on here because you have a word called notice of violation. Between the period of March 14th, so suppose we get the notices a week later, March 21st, we had finished gone through almost everything by sometime around June, maybe June 7th. We closed everything and everything was completed on that report. And the same thing with the next building. And the same thing with the third building. And maybe what was left was not much beyond that. So then they filed their case and waited, I think, until sometime in December. They filed their case in June. Then by December, they filed a motion saying they are seeking what's called a preliminary injunction. An injunction is an order directing you to do something or restraining you from doing something. It has two potential sides. It can direct you to do something or not do something. In this case, they were claiming that they had 4 causes of action in their complaint, and they were claiming that they needed us restrained, or they needed me restrained from certain things, including managing my own buildings or living in my own building, which, of course, if you own the building, it's something wrong with saying you have no right to live in it. And that goes back to a complete violation of your property rights. Thankfully, I had a very, very committed attorney. Julie is a very feisty Asian woman. She was just troubled that anyone could do what they were doing. And she was so determined. She's a small office. She had an office where they had two people and additional maybe help. I think maybe just being foreign. When you come to this country and you see, we have expectations of this country. So when we come here and we see what we loved about the country being violated, I think it makes especially the foreigners want to stand up and say something's wrong. Whereas I think Americans have kind of like taken it so much for granted that its rights and privileges that are endowed within the Constitution are to be, trivialized and taken lightly. Julie wouldn't have it. So she became very organized, hired an expert witness who was a building inspector, and she took depositions of the guy who's at the time the deputy building director. His name was Dennis Lowry, something like that. But she took a deposition of him and asked him very straight short questions about the procedures, what they were doing, and how it violated our rights. And she also went through each one of the tenant declarations that they were using as their evidence to support their request. And she attacked almost everything they said through responding declarations through me and through actual facts. And in the end, when it came for hearing, in the hearing of March 16, 2016, the judge denied their request. To all those people who assume that the good things only come because you have one race or other, I think the surprise here is the only one man who attempted to do right by this case was a white middle-aged man. And we'll read what he said. First, his order denying the motion for preliminary injunction was issued on March 3rd, 2016. He says, as this motion's first sentence states, plaintiff, city and county of San Francisco seek to end this case based on loyally drafted declarations. This is not typically how the American legal system works. Rather, disputes are best ended by trials with live testimony from witness stands, subject to cross-examination, that greatest legal engine ever invented for the discovery of truth. The point is demonstrated by the authority the city cites to try to support the scope of the injunction. None of the injunctions issued was any one of them issued without live testimony and cross-examination. It is not to say that a preliminary injunction has no role. Of course they do. However, for several reasons, the particular preliminary injunction here is unwarranted. First, much of the conduct alleged by the city's injunction paper is historical and not ongoing. The city concedes, for example, that the defendants have cured most violations. And he cites plaintiff's memo, page 12, lines 12 to 14. Likewise, the city concedes most of the tenant declarations who complained of the defendant's conduct no longer live in the buildings. He cites plaintiff's reply, page 5, lines 19 to 22. This is quite different from the case that the city relies upon, IT Corporation versus County of Imperial. Second, the city undercut its arguments for a preliminary injunction by failing to seek one until December 2015, 6 months after filing their complaint. Third, many of the 40-some terms in the city's proposed preliminary injunction are unprecedented in scope and restrictiveness. For instance, in one of its 13 pages of the city's injunction, 1, they would outlaw the use of all security cameras on defendants' buildings. 2, require that all tenant services, including parking, trash, access to common areas, to be maintained exactly as is. 3, require defendants to get court approval before serving any legal notice. Well, that's actually already a violation of your legal rights. You shouldn't have to have permission to serve a legal document. The court then goes on to say, even injunctions the city called draconians, they don't go this far. Fourth, the city has submitted declarations that give polar opposite versions of the same events. The tenants at these buildings and the declarations from the expert witness and Ms. Gihagi. For all these above reasons, the preliminary injunction is denied. So that was the ruling from Judge Umar. And now we look closely at what the actual transcript said. So the court goes on to say, can you tell me if there are any outstanding violations? Response by Deputy City Attorney Weatherford, 1 violation at the building at Eureka Street. Court questions, 1? Weatherford, yes, 1 notice of violation. The reason why that's important is by the time this is all going on, the court's actually asking a very good question. You're in court, and the court says in the transcript, so for these 2 violations, it turns out there was something else that they were refusing to give us a permit for, to cure, to fix it. You want this 40-item preliminary injunction that you say does not put them out of business, but I think that's open for argument. In other words, the court recognized that what they were trying to do through this preliminary injunction, the court called it, put them out of business. It's the judge's actual language, put them out of business. And the reason why that's important is this injunction, we're going to see that the judge, the first judge, Richard Ulmer, denied. This amazing white man becomes the same judgment or the same injunction that the next corrupt Bradstreet ends up actually agreeing to. And the only way she was able to agree to that injunction was by using a method called terminating sanctions, where she would not allow our evidence to ever come in. So she would give the city a plate where they would have unopposed evidence and no one would fight it. And you heard the first judge actually quoting from his own language when he talked about this amazing, the best instrument ever created in the American system, which is that trial where you have the cross-examination of witnesses so we can get to the truth. She did not want that because she knew that would raise issues. So she devised, and that's what makes corrupt judges very dangerous. They're crafty, they're cunning, they're smart, and they try to get to their end goals, regardless of what the law states. Judge Bradstreet came into the case after the city got a chance to challenge the Judge Richard Ulmer. And corrupt Bradstreet was then designated as the judge. Is the city or is anyone allowed to challenge and remove a judge from hearing the case? Answer, yes, there's a way to do it. And the state provides under California Code of Civil Procedures 170.6 a method through which you can challenge any judge. You don't have to give any reason. You can just say, I think this judge is biased against me. You don't have to give any evidence, and you have a chance to challenge a judge. But that right is restricted as to the timing when you can do it, and there are some restrictions in terms of what you can do and cannot do. But they were able to do it, and so that was an important accomplishment or feat that they were able to accomplish. After Judge Bradstreet ruled against them in March 2016, a few months later, the city, now in May, decided to run into court again and say that they were very prejudiced, that they believed that they needed to have the trial advanced. The trial had been scheduled somewhere around February 2017. Now we're in May 2016, and they're saying they're prejudiced and they need the case advanced from February 2017, which is not too far away. They need it shortened. So the court in San Francisco, without any regard for how many witnesses and motions that were still outstanding, agreed to advance the case by 4 months to October 2016. Now we're talking about May, June, July, August, September, 6 months to do all the discovery, prepare for the case, and have people ready. Sadly, during this time, the Ms. Nong, who was the defendant's attorney, who was our attorney, was having personal problems. Her father was very ill and likely to pass away anytime. So she had to travel to Asia, and she notified everyone that she had to travel, and this was mandatory, she couldn't get around it. Despite knowing that, and knowing that Ms. Nong did not have a big company and big staff, the city used that opportunity during that time, which is July 2016 through somewhere around end of August or middle of September. They ran to court almost every other day and they would say to the court, we need, these people, Ms. Giagi and her companies are refusing to answer all the questions. They would pile in. They had 3 attorneys at the time, triple teaming Ms. Nong. So they're sending emails from 3 people saying, every day I want something. And if you're a small office trying to gather evidence and trying to respond, on top of doing your own motions, you can only do so much. So they could only do so much at that time. And they took advantage of that to seek what's called motions to compel discovery. And each one of those orders was being used strategically because they had a goal in mind. And they knew that now Ms. Nong's away, there was no one to help in regards to what was going on. And at the time, I didn't have a good grasp of law as well as I do now. And so I didn't know everything that was happening, and I hadn't really necessarily had not been involved in litigation up to that point in my life, so I didn't have to know much of law. And I also assumed that the system is pretty fair and honest. I believe it was in August, end of August, the court decided that Judge Uma, who had been the judge on the preliminary injunction, would become the trial judge. So in this system, when they make that announcement, they give you 15 days to decide if you want to challenge him. So the city used that new assignment, single assignment judge, to then challenge Judge Umar and say, oh, he's biased against us because he had ruled against them. So now they were using that to say he's biased against them. And it's kind of sad because now here you have a big city crying and saying that they think a judge is biased against them because he didn't rule for them. And the presiding judge, who was Judge Stewart at the time, agreed with them and decided that Judge Umar would be recused. Within a few days of that, they hired corrupt Bradstreet to be now the new judge in the case. This is also a very sad time because what's also going on is Ms. Nong has been out of the country in Asia. During that time, I had been very concerned and I had found another company to come and help us on the case. And they were trying to get up to speed, and they're a mid-sized company, but they could only do so much. And then when they learned that Judge Uma was being removed from the case, because Judge Uma had already indicated that he would push back the case to allow everybody to do the discovery, because the trial process is supposed to be fair. You don't want to ambush people who are not ready for trial by denying them a chance to do their discovery. So he had already told the city, or he had expressed that he would definitely be continuing the case because he did not agree that they should have advanced it by so much. It's important, I think, as well, to take a look at what Michael Weiss had said in regards to his own declaration as to the complexity or the issues in the case. So I want to just read an excerpt from a declaration of Michael Weiss in regards to where he talks about the complexities and how the very idea of what they were representing to the court did not reflect the truth of what Michael Weiss had actually told the court. So in the very first months after filing their case, Michael Weiss, Deputy City Attorney Michael Weiss, filed a declaration in court, and he said in paragraph 15, plaintiffs anticipate that there will be numerous pretrial motions, some of them raising difficult or novel legal issues that will be time-consuming to resolve. Among these may be a motion for preliminary injunction. Discovery will likely be extensive and hotly contested. Key word, extensive and hotly contested, requiring judicial oversight. The discovery will also explore, so they talk a little bit about the complexity. And then they go on and they repeat in paragraph 16. This case will likely require the court to manage a large number of and substantial amount of evidence. Plaintiffs anticipate a large amount of documents to be produced by defendants, including corporate documents, financial records, contractor invoices, business dealings. But this is interesting. So in the beginning, before Judge Uma ruled against them, he was saying this case is complex, and what he's telling the court is that the discovery is going to be very extensive. That is clearly contradicted by the very idea of what they try to do in the end. When they lose the preliminary injunction, they went to court and now used the opposite. That the case, they said, oh, Ms. Nong is a very smart attorney. So that fact that she had won against them, they were now using it against her to to try to negate these very material points that go back into due process. You have a right to discovery and to be prepared for trial. You just don't ambush people and say you're going to trial. And then they used the fact that there was very hotly, as they said, the discovery will likely be very extensive and hotly contested. If you're expecting the discovery to be extensive and you're conducting it over a period of a few months, then you can expect that you will have, as you said, hotly contested. But you don't run into court every time, and they were running to court almost every other day. Between the time period of, I would say, mid-July to sometime around August, it was on a weekly basis they would run to court for another motion. They knew what they were trying to do was set up for what's called a terminating sanction. A terminating sanction can have two elements. One, they can call it an evidentiary sanction, which means that we're not going to allow certain evidence that you have to come into trial. So it's like your hands will be, you're stuck with one hand behind you. And then there's another type of sanction which says issue sanction. We're going to rule against you on certain issues and say you've lost already without ever giving you a day in trial. And the reason why this is an important element for Americans to understand and people to understand is it's being abused a lot more often in judges who have corrupt intentions to get to the outcome that they want. And we can now read why Judge Bradstreet was able to use these terminating sanctions. So they knew, the city knew, they could not get a terminating sanction in front of Judge Ulmer. But they knew that this new judge, whom they had already researched, this is a small community. San Francisco is what, 49 square miles? The Castro, which is where some of these buildings are in, Mission, small community, they know each other socially. And so everybody has a good knowledge of each other. And they knew that they already had researched Judge Bradstreet's background. And sadly for my attorneys did not do any research on this judge's background to challenge her. But it's very sad because if they had, it might have become clear that this judge is she's an activist judge and very, very biased. So we're going to look a little bit at Judge Bradstreet's background. And Judge Bradstreet, the best way to understand her is to read some of the articles, the press releases that have been made. In a Los Angeles Times article in June 2003, let's see what the LA Times said about her. California judges who belong to the Boy Scouts of America may have to remove themselves from cases involving gays under the rule approved by the California Supreme Court. Because the scouting group bans gays, judges must disclose membership to it when it has a potential to give the appearance of partiality. The court said that the Supreme Court was amending the state's Code of Judicial Ethics. The court added language to the ethics code suggesting that judges disqualify themselves from cases where a member in an anti-gay group could be viewed as conflict. If the attorneys are openly gay and the litigants are openly gay, this could be potential under the amendment, a duty to disclose his membership, said Angela Bradstreet. The Code of Judicial Ethics prohibits judges from belonging to groups that discriminate against minorities, women, and gays, but exempts non-profit youth organizations. Although several bar associations favored removing the exemption for the Boy Scout, the new requirement is still a very positive step, Bradstreet said. The change will lead to more awareness for judicial membership in these organizations and more thought by the judges about whether they want to remain in cases in light of their membership. Go to the next article. This is now in 2003. This is now being written by the advocate.com editors. The California Supreme Court has decreed that state judges who are members of the Boy Scouts may have to disqualify themselves from hearing cases involving gay issues. Cases involving gay issues. Well, if you have the potential that somebody is claiming that they are being evicted because of being gay in the Castro, well, that involves a gay issue. Let's go forward. Legal experts say that the move by 7 justices in the nation is the nation's first ruling following the U.S. Supreme Court decision in 2000, allowing the Boy Scouts to bar people from membership. There is no other state that has adopted the express rule like this, according to Cynthia Gray, Director of American Judicial Society, Center for Judicial Ethics. California judicial canons already demand that judges remove themselves from groups that discriminate against women and minorities, rules adopted 5 years ago forbade judges from being members in organizations that discriminate against lesbians and gays. The court said Boy Scout was entitled to define its own principles. What the California Supreme Court appears to be saying is that the judge who is a member of the Boy Scout may have to disqualify himself in an appropriate case, said Angela Bradstreet, who was a former San Francisco Bar Association president who urged the Supreme Court to alter its ruling. So she was the advocate in regards to this issue. Judges with ties to the Boy Scouts would either have to step down or notify litigants in cases dealing with anti-gay discrimination. Or the opposite of anti-gay discrimination, the similarity would be when the tenants claim that they believe a landlord is discriminating against them because they're gay. In this particular case, we could go a little bit more forward and we can see that Cora Bradstreet had been very, very active. She was an activist in pushing for the change of these laws.
Oh yeah, they completely pandered to the idea that the city attorney was representing gay tenants, even though not all the tenants that I evicted for Hanky were gay. The judge should have recused herself, and especially since maybe the defense attorneys didn't know, but Angela Bradstreet has a reputation of being completely pro-tenant and that she doesn't apply the law if she doesn't agree with it, particularly what is one's principal place of residence.
By the time we get into the town hall meetings of 2015, Angela Bradstreet, the past president of the Bar Association of San Francisco, is the mother of the Scout ban. When I asked her last year if she thought a Muslim judge from the anti-homosexual mosque could be impartial with her, a lesbian, she answered, "You have to start somewhere." Translation: Boy Scouts, you're first. Religions that aren't politically correct will be next. And don't expect any assistance from civil libertarians. The local ACLU has no position on this Boy Scout ban. Some judicial watchers are convinced that the state Supreme Court, led by Ron Gay, will adapt the ban statewide. People who are saying that they don't know what they're talking about, it's because we don't know what we're going to do, George told me. First, an advisory committee has to weigh in, and then the justices will rule, probably within 6 months. Maybe Bradstreet and company can push next for a measure requiring them to wear badges to alert those in the courtroom to the Scouts amongst us. Yet, with the absence of any problem, Bradstreet justified banning by arguing the judges must appear impartial. The reason why we go into a lot of detail to give background on Judge Bradstreet, and I again repeatedly call her corrupt Bradstreet because she's absolutely a very corrupt judge. Smart judge, but very corrupt. By 2015, California Supreme Court, the state Supreme Court has voted to prohibit judges in California from belonging to the Boy Scouts, which has 2.7 million members. So by 2015, it became the law. So 2003 through 2015, she had been campaigning against this. So this is very interesting. This case is going on in 2016. She has had a crusade, marshalling all her efforts when she worked for the San Francisco State Bar to 2015 when she gets her goal accomplished. And she thinks to herself, that's the first victory. Then you now come into the next point where now she's become actually assigned as the single judge in this case. Bradstreet herself is openly gay. It's important that by this time, Michael Weiss, who's also openly gay, no problem, is the deputy city attorney who had been sued. I had sued him individually in his individual capacity, where he could lose a lot in an individual capacity in the federal court in Oakland. He is the main, representative for the city attorney's office. By then, Peter Keith, who's also openly gay, who's senior to Michael Weiss, had joined the case. Now we have two women at the time as well involved in the case. One of them is Victoria Weatherford. We do not believe she's gay, but there was also another member from the city attorney's office. So now you have the judge is openly gay, and you have two prosecutors who are openly gay. Now they're changing their whole presentation of their case to make it sound as though the whole case is premised on people in the Castro. So we're going to go through and look at some of the transcript in terms of how Michael Weiss presented the case and how Alison Lushevsky, who's herself a very openly lesbian woman, was presenting the case. So from the tenants that we have, who, as the judge said, did not even live in the building, we have Alison Luszewski, who's openly gay. We have James Austin, who lived at Eureka, who's openly gay and married to Ray Schreiber, a man who's about 6'5" and weighs 250 pounds. We have Kelly Kimball, who had moved out so I could move into the unit, and I lived in it, is openly gay. We didn't know, I didn't know at the time, that Ben Hutchinson, one of the other tenants, was openly gay. Then they tried to bring in another last person by the name of Darcy Harris, who was also a lesbian woman who had moved out because she was running a gymnasium out of the building that I lived in, and that's a no-no, especially when I live in the building. So if you have a case where they're saying they have potentially 15 witnesses, and 6 of the witnesses who no longer live in the building are claiming or trying to now position themselves as, oh, we feel that we were being targeted because we're gay, and you have 2 of the prosecutors being gay, and you have the judge as being gay, there's no way that what was good for the goose when Bradstreet was campaigning against the Boy Scout does not now become good for the gander, that she must recuse herself because there's an appearance of impropriety, but yet she did not. That's the central issue in this whole case, and why the rulings are absolutely corrupt and should be reversed. So now we're left without an attorney. And during this time when we're left without an attorney, the city actually makes a ploy to run into court and continue getting more discovery sanctions. Even though we don't have an attorney, and any judge would simply say, we're going to give you time to find representation. They didn't care about that. During this time, they filed this motion, and I think reading into the court, the declaration from the 3 attorneys who filed declarations in court will give a little bit of an understanding of what was going on. So let's take a look at the declaration from Richard Diesel, who was the previous attorney. And he declares in paragraph 8, on September 15, 2016, the parties appeared before the presiding judge, John K. Stewart, for a hearing on plaintiff's challenge motion 170.6. Judge Stewart ruled in favor of plaintiffs, the city, and disqualified Judge Umer. As a result, defendant's pending motion for continuation of trial, which was set for the following September 6, 2016, before Judge Umer, was taken off calendar. In light of our trial commitments, our firm had to withdraw. It's very sad. So now you have a second attorney that's leaving the case after investing time, and we're now supposed to be going into trial. This is happening in middle of September, and the trial is scheduled for middle of October, around October 16th. Now let's listen to the declaration of Ms. Nong. She talks a little bit about what was going on as a sole practitioner, and with this litigation consuming an immense amount of my time, I thereafter aggressively sought help. However, I was unsuccessful in recruiting sufficient competent talent to assist. I was out of the country from July 21st through August 11. During this time, I was essentially out of communication and unable to participate meaningfully in the defendant's defense. Prior to leaving the office, and in light of the plaintiffs, the city's recent disclosure of nearly 80 witnesses, I filed a motion seeking continuance of the trial date, which was scheduled for hearing on August 16th. However, the court failed to hear the motion altogether on August 16th. By now, again, timeline, the city loses the motion for preliminary injunction. They come to court and they ask to advance the case in May 2016. Then thereafter, they start doing discovery very, very late in their schedule. They're starting discovery sometime in April or May. And then they disclose they are planning to call 80 witnesses. How can you actually depose and prepare for 80 witnesses when you have at this time, you have less than 6 months to your trial? This would be impossible for anyone. She goes on to say, while I was gone, plaintiff's counsel placed tremendous pressure on my small staff to sign on things they certainly must have appreciated required my input as the attorney of record. This effectively created a situation where there was no attorney of record for an extended period of time. When I returned, I was confronted with a mountain of emails and urgent issues, the majority of which I was unable to address until middle of September. Additionally, on or about August 21st, due to my client's concerns, I received a letter from Ms. Kihagi terminating my ability to represent her because I had been away for a very long time and I'm a small office. Upon this realization, I should have immediately filed an ex parte continuance to permit my clients to substitute counsel. However, I did not. it means she's so overwhelmed that she didn't even recognize that she should have filed for a motion asking the court, please stay your hand, give them a chance to find a new attorney. But that didn't happen. During this period of time, including the time before I left town, I was inundated with thousands of discovery requests, including requests for production, requests for admission, form and special interrogatories, which were directed at each of my 7 clients. It was beyond my individual ability to respond. It was effectively chaos. Specifically, plaintiffs started propounding discovery in April and May 2016. I regularly sought reasonable extensions that were regularly declined by the city, as I endeavored to respond to the voluminous discovery the best I could. I personally do not believe that the plaintiffs' counsels engaged in meaningful meet and confer efforts, but rather were filing motions for every single set of discovery that they had served. I would focus on the key word here that Ms. Nong has identified yet another pattern of practice here: the city's unwillingness to engage in meaningful meet and confer. The meet and confer is an important legal process to avoid having people run to court before they consult each other and try to resolve things meaningfully on their own behalf. But if you just have language in the legal system that even the city prosecutors know they're not going to comply with, it gets abused. And in this case, what they were running is running into court every day and making it sound like the defendants, in this case us, my side, is not complying with discovery and failing to recognize what you just heard from 2 attorneys. One of them is quitting because he doesn't have a continuance. The other one is on a family emergency and he's a small firm, and they recognize that she's away from the office, and so they're trying to jam in as many orders and as many motions as they could. Additionally, plaintiff's counsel then refused to cooperate with me on scheduling depositions. I repeatedly informed plaintiff's counsel that I'm unable to appear given my termination and scheduling that was done with Blestel's firm, and requested more time. I was able to provide deposition dates October 7th for Julia Mwangi, Ms. Kiagi's sister, but plaintiff's counsel refused. Thus, they would not wait 2 days for one deposition. So imagine saying we refuse. They're not going to allow Julia to testify when the attorney is saying, I have a conflict, she has a conflict, and she's asking them to delay by 2 days. So they could run to court and tell the judge, Corrupt Bradstreet, oh, we were not able to get the deposition of Miss Julia, when she had already sat for half a day's worth of testimony. Third attorney who actually provided a declaration to tell the court, telling Corrupt Bradstreet why the court should have denied the motion for the terminating sanction was an attorney by the name of Greg De La Pena. And Mr. De La Pena testifies that he did give the city many opportunities for scheduling the depositions and also his efforts in completing the discovery, but then they were not interested. I'm an attorney licensed to practice in the state of California. I represent the defendants. Our firm was only recently contracted to represent defendants and makes its first appearance. This is the first time he's showing up, and he's coming in to represent a case where this city is saying their case should be completely tossed out and they should be sanctioned with a complete loss. Attempting to address the pending motion was an enormous effort. 3 attorneys have essentially been assigned full-time to review the history of the litigation, including and particularly the extensive discovery in this case, and to determine what responses have been made, what discovery is outstanding, and what discovery responses need to be supplemented, immediately addressed. In the course of our brief involvement, we've reached a conclusion regarding the deficiencies, and we're committed to ensure that they are supplemented in accordance to the court's orders. Specifically with regard to outstanding deposition of Ms. Kiagi, we're offering to produce her for deposition on October 19, 20th, 21st, 26th, and 27th. With regard to Ms. Mwangi, Christina, we're offering 27th and November 2nd. Ms. Julia, we're seeking to confirm her availability for October 22nd, 29th, 5th, 12th, and the 9th. With respect to property inspections, defendants will make all properties available for inspection on the 19th and the 28th. But this is interesting. When the new attorney, Mr. Greg De La Pena, made all these offers of all the things that they were saying, oh, we weren't able to do property inspections, we weren't able to get a complete deposition of Ms. Kiagi. I'd already sat for a full day's worth of deposition, but they were not satisfied, and they were simply saying, we need more time with you. But I'd already sat for a full day. Julia had already sat for half a day by this time. And then Mr. De La Pena offered them dates to actually do inspections, and I showed up at the buildings as had been offered. City did not show up. So in other words, they never really wanted the discovery. They were using it for a ploy to try to take advantage of what's considered a terminating sanction.
This entire case was based on misrepresentation. Unfortunately, Judge Bradstreet doesn't care. She doesn't care what she didn't care what the facts were that were in favor of the landlord.
Terminating sanctions should not be imposed until the court has attempted less severe alternatives and found them to be less successful. So then she went on to say, well, here there are maybe 7 orders, and because they've tried them before, not recognizing that there were no attorneys to comply with the orders, she said, tough luck, we're issuing terminating sanctions. And that's how the judgment ended up being the way it was. After saying that terminating sanctions should be sparingly used by judges and should be tailored to exactly what was withheld, she comes in with an order that makes no sense. And this tells you how biased this judge is. She says, as to the failure to comply with repeated court orders that plaintiffs be permitted to timely inspect the building, the court awards the following: issue and evidentiary sanctions. Now she's doing 2 things. One, she's giving an issue sanction and an evidentiary sanction. And she says, if the plaintiffs meet their burden of proving their claims that defendants created unlawful or substandard or unsafe conditions in the building, the court will determine that such conditions still exist at the time of trials, and they're prohibited from presenting evidence that any such unlawful conditions have ever been cured or abated. We can come back and look at some of the testimony of the one housing inspector who saw all the buildings, and he testifies. The housing inspector, his name was Anthony Lepe. He was asked a question, which we'll go back, but in line 25, he says, okay, I'm just trying to make sure I go which way to remember it, you know? Based on the inspection you did during the first 2 days, did you reach any conclusion about the buildings that you were looking at and how they were maintained? Answer: the buildings were generally well maintained. Question: and so when you say the buildings, are you drawing a distinction between the buildings and the common area versus the apartments, or do they apply to the apartments as well? Answer: well, that was a general observation, but the units were also mostly pretty good too. That's the only inspector who ever went to all the units. So they'd like to make it sound like you have something that's substandard, but the housing inspector is actually testifying under oath that the buildings were generally, he said, well maintained, and then as to the units, he says they were mostly pretty good too.
I would have loved to have been a fly on the wall when Michael Weiss is trying to tell their building inspectors, these are terrible, awful things, and where the building inspector's like, you know, actually her buildings are pretty nice. Oh, she fixes everything on time. You know, like, what do you want us to do? It's like, what? You can't.
The city wanted to use this idea of the image of too black, too female, too feisty, that the black landlord could only be a slum landlord. But yet the testimony from some of their own witnesses was not actually bearing what they were trying to, to put up. Mr. Lepe was then asked, what was his understanding of why the city was actually conducting the city inspections? He was asked, at any point during this inspection, the task force process, were you told by anybody other than the city attorney representative that complaints had been received by the tenants in a particular unit? Answer: I was not part of the information initially. Question: you said initially, did you learn about it later? Answer: yes, I learned about it later that there was a problem and that it was known in the office. Stephen Mongavan mentioned, plus I think there was a newspaper article. Question: and since this was the first time on this case, what do you mean her business practice? What is it? Who are the complaints generally about? Answer: evicting people. This is interesting because now you're hearing from the one housing inspector who has been to all the units. And generally when they create this thing called the task force to go and look at rundown buildings, there is a real reason why they're being created to do so. But in this case, the motivation for why they were being created, precisely what I said. We have the document, and it speaks out that they wrote a letter to the building department saying we're going to inspect, we were creating a task force to investigate Ms. Kihagi because 1, she evicts long-term tenants, and 2, she is allowing illegal aliens to live in her buildings. 2 reasons.
They welcomed all these inspectors, because they had cheap rent-controlled apartments that they enjoyed, and they didn't like the fact that the landlord can exercise such a right that the landlord's rights were superior to theirs.
Statement of decision, she talks about Hill Street. She says, on March 4, 2015, defendants constructed a barricade wall at the bottom or near the exterior staircase, blocking egress or access to the garage. The defendants did not obtain permit for this work, which involved building code. As of January 12, 2017, there has been 681 days, and the court finds that this constitutes a violation for 681 days. Now let's talk about this. This thing that she's calling a barricade, the city had come through in their task force, and they had said that there was an illegal laundry area that had been put in by prior owners, and they had said that that laundry area was not properly ventilated. And given that it was not properly ventilated, and you had tenants that would cry and make any complaints about the fact that if Ms. Giagi or if I came in and tried to do the work, they would find a reason to complain. So what we said was, there's a laundromat 1 block away, rather than have any fire risk, especially now that we're on notice, or have any problems, and because we don't want to create dust in tenants' units by trying to go all the way to the roof, we're going to block this area with plywood. It's just a room that's not used by anyone except the owners. And we barricaded it with plywood. And that's what she's now claiming, that that's illegal. Yet on the other hand, they're saying that they have notified you that you have an illegal laundry area that we did not have anything to do with. Prior owners had done it. But yet now, if anything goes wrong, you could be held liable for it. So you're caught in a catch-22. The interesting thing about this is the San Francisco Rent Board has created a mechanism for how landlords can handle some of these things, and it's called a reduction of service. And when you reduce somebody's services, you have a right to give them a credit, because you don't know, especially when you're going through litigation, how it could be resolved, how it could be used against you. So we offered each one of the tenants $50 credit, and we said, please do laundry. There's 2 blocks away. We were right near Valencia. There was a laundromat, and we just say that might be the best solution for now. So that was an adequate solution of that issue. And under the rent ordinance, that is an acceptable solution than having to deal with tenants suing you for dust, for lead-based paint, or anything else that they could think of, because they were looking for anything that they could come after you for. And that was a good decision, and I think most prudent business people would make the same decision in those circumstances. Here, in the final order by Corrupt Bradstreet, she's using that plywood that blocked access to that laundry room and saying it's a barricade, and she's saying it's illegal. And now she's saying 681 days. And she does that the next thing, and she says, let's talk about the next thing. She keeps counting these things, which will count. And so, for example, in this particular building, by the time she's done, she comes in and says there's a total of 821 days of total nuisance, just from one building. And by the time she went through building number 2, building number 3, Guerrero, building number 4, Eureka, those were the 4 buildings generally, she came up and said a total of 4,400 days of violations. And each one of them is something as crappy as what we just talked about. And by using that, then she said, we're going to penalize you, even though they were fixed or the building department doesn't think it's a big deal. She said, we're going to penalize $250 for each day that any one of them existed. Multiplied by 4,000, and you come up with a penalty that was almost $1.2 million. Playing into that bias of the gay agenda. So in one of these situations, one of the tenants at Eureka, his name was Ray Schreiber. He claimed that I was in the building on a Sunday afternoon and that he saw my face and he screamed and they ran in and they closed the door. And Miss Uchiyama then turned up to him and said, why were you running away? Just because you saw a black face? And he said, yeah, she looked at me with catatonic eyes. He admits that his problem was that my appearance scared him. This man weighs 250 pounds, is 6'5". I am 5'7". I weighed less than 115 pounds at the time. I had lost so much weight. And the judge, Corrupt Bradstreet, believes him and gave a penalty and said, by doing that, scared a tenant, and that's considered harassment. And he said, by me looking at him with my eyes, nothing special, $5,000 penalty.
His testimony was so incredibly laughable, but on the other hand, if you want to look at him as a sympathetic gay man, things scare him easily when he opens the back door. Even though the landlord was on the common area, outside the door, overseeing construction on her own property, but just happened to be black, by the fact that scared him, that's completely irrelevant. The thing is, he had never met Anna Kihagi before. By the time, since 2015, but to the time of this trial, because of the press releases that were released by the city, Anna Kihagi almost became like an urban legend, like the urban legend of the most evil, greedy, black landlord.
So by the time the case was done, there was a $2.5 million judgment for penalties. And then the next part where she gets you is she gets you for attorney fees. And by this time, the city had made an election of remedies saying that they were looking at unfair competition. Unfair competition law does not allow for any attorney fees. But corrupt Bradstreet would not let that go. She wanted to give him more money. In other words, what she's doing is a redistribution of wealth from too black, too female, and too feisty, redistributing your money to the city. So she makes up an order and says, oh, I'm going to grant an injunction under this rent ordinance that allows attorney fees and under this building code that allows attorney fees. So in the end, she gives them another $2.5 million. Well, an interesting part is that the state of California has said that when you have the city or the state prosecuting claims of building issues, and there's a clause that says that the prevailing party is entitled to reasonable attorney fees. In the actual state code, it says reasonable and actual. There's the key word, and actual. And is a conjunctive word. You would never use that word if it had no meaning or if it had no relevance at all. In this case, Michael Weiss's salary was something like $160,000. So if his salary is $160,000, but Bradstreet is awarding him almost $1 million for his time in the case for a year, I mean, that just goes to show you the egregiousness that was going on in this particular case. And no one wanted to look into these things. The case then goes into, we filed an appeal on it. And while the case was going on appeal, it gets directed to Division 1. The judge, the presiding justice in Division 1, I don't have his first name, but his second name is Justice Humes. Justice Humes is married to another gay judge in the San Francisco Superior Court, and he himself is gay. So now you have every part of the gay connection, all kind of like getting together to kind of go, every direction is geared into my case. And you ask yourself, of all the different divisions in the First Appellate District, that it goes specifically to this judge, and you think there is, that's a coincidence? There are no coincidences. It went directly to this judge because they wanted a specific outcome, and that's exactly what they got. And he would rubber stamp anything, and the case was expedited, and then he went through that. So what happened after the case went through appeal and it was finalized? So after the case, there's a monetary part of the judgment. We pay it, or we've already bonded it, so that gets paid through the insurance company. The second part is there was still an injunction. And as we discussed a little bit earlier, an injunction is simply an order from a court saying you must do this, or you are restrained from doing that. So it's a court order directing certain things be done or not be done. So given that it's a court order, it's not a monetary judgment. The city generally took advantage of the fact that the injunction, so despite awarding almost all this money, the next thing the city did was they awarded attorney fees. And not attorney fees, they had an injunction. And in this particular injunction, we'll look at some of the key sentences or key statements. So let's look at it. The injunction defines who the parties are, and it defines that the city attorney is one party, and then they try to add in the state of California as another party to the case. And they name the defendants as the other party. And in the injunction, it says, any party or any person subject to this injunction may apply to the court at any time after making a reasonable effort to meet and confer with the other parties for further orders and directions as may be necessary or appropriate for the construction, application, carrying out, or enforcement of this injunction. The key word is meet and confer. So the appeal decision comes through sometime around March 14. Within less than 2 months, the city runs and says, wow, we're running to court and we're now going to enforce our injunction. And they run to court and they now realize by this time that they had been running, after they got the $5.5 million or let's say $5.2 million, they tried to go to Bradstreet to say, oh, Agi is not complying with the injunction. It turned out that injunction is, while the appeal was going on, was stayed. So they couldn't get anything out of it. And then they had some sections that they wanted enforced, and the judge said, well, they wanted a contempt order, and the judge disagreed with them. So in this case, now Bradstreet's milked money out of you, and now she's trying to pretend that she's being fair. She's still a corrupt judge, and she's still terrorizing you, but essentially now she says, no, let's you guys go meet and confer. So the order says within, any party can come to the court after reasonable meeting and confer. The second part is it says, within 60 days of the entry of this injunction, defendants shall hire at their own expense an independent property manager approved by the plaintiff city and county of San Francisco, or failing approval by plaintiff city, the court in Department 501 to find a manager to perform all management duties ordinarily associated with each of the properties. A defendant shall provide plaintiffs with the name and contact information of the independent manager within 7 days of the date of hire. So now the case comes through. By the time the appellate decision's on, we already have a property manager. And they did a pretty good job. They were keeping the building 100% full. They were dealing with tenants. They were doing a good job of dealing with everything. Now what the city does is they come in and they run to court to a different judge. They run to a new department, Department 501, in front of a judge whose name is Charles Haynes. Judge Haynes is also now a gay judge. And the city comes in and marshals and said, oh my God, we've got this decision that was affirmed by the Court of Appeal. As a new judge, you're assuming these people must be so bad that the Court of Appeal affirmed this, not realizing that Judge Humes is part of the political agenda that had been orchestrated by the entire mechanism. And again, the mechanism starts way before. It starts that the case started with a couple of tenants organizing. Alison Deshevsky, claiming she's in the Castro, goes and speaks to politician at the time, Scott Wiener, who was a supervisor, who was trying to get elected to the Senate in the California political system. So he needed to continue creating a lot of noise. Now, Scott Wiener had worked for the city attorney's office. We didn't know that at the time. So he, of course, had his cronies and immediately put a call. And his call, unlike any other call that would go in that might not get attention, he was calling in from the Castro, claiming that there were tenants in the Castro being evicted by somebody who had worked in the Castro, who represented the Castro himself as a supervisor, who's gay, and now speaking to a department where the person assigned to the case was Michael Weiss, who's also gay. The whole case reeks of like the gay agenda. The very same thing that Bradstreet had said should be the exact reason why you should recuse yourself. So based on the rulings by Bradstreet, this new judge, Haynes, should also have recused himself. He doesn't do that. They know who he is. They already have done research. We don't have the resources or any people or any attorneys. By now, the attorneys that had represented us, who had come to us through the insurance company, had already sought to be recused. So we don't have any attorneys representing. We are very skinny. When the hearing came to Judge Haynes in July 2019, he issued an order saying that he's granting the city's request not to hire an independent manager, but to hire a receiver. And that they would then have this receiver act as their de facto property manager. The reason why this is such a big deal is a receiver and a property manager are not the same. The original injunction was already abusive in itself. The injunction says in paragraph 2, it's saying defendants and each of them shall not have any contact with any past, present, and future tenants of the property, whether orally, in writing, electronically, or in any other way while the injunction is in effect, except that defendants may collect rents until the independent manager has been hired to commence his management duties. So wait a minute, I live in the building, but I'm not allowed to talk to any tenant who is not part of the city case, because it's saying past, present, or future. Excuse me, the future tenants have no complaints, they have no beef. The present tenants, who are mostly new tenants that we brought, that I chose and selected to come into the building, have no beef. I live there myself, but I'm being told they shall not have any contact with any past, present, or future tenants. It's already a very unjust order. But what's actually more technical is then it goes on to say, individual defendants shall not enter any tenant's units on the property except when accompanied by independent manager with the independent manager's permission, provided the independent manager finds good cause in his sole discretion and only upon providing at least 24-hour notice of defendant's intent to enter. In other words, the property manager is now going to be directing the owner to say, you don't have a right. Imagine if there's a leak in a unit. Imagine if you suspect, I live in the unit, by the time you get the property manager in, suppose there was a fire or there was a leak, now you're being told, no, you shall not enter the tenant's unit. You can't go fix the problem. You can't go in and open the door for the plumber. Yet you live in the building and you know it's a building that you have to protect. This order was completely already violative and very, very wrong. And anyone looking at this would know that this order is abusive. The Court of Appeal, if it did not have Judge Humes, another gay judge, in the case, would have done the right thing. But it's also interesting that almost every one of the cases that have involved me regardless of how the source came, all went to Judge Humes. And the reason I believe is it's not accidental, it's intentional, because they knew they had an ally in their side that would rubber stamp in and rubber stamp almost anything that came from any person. And regardless of what laws were being broken, he would continue to allow those laws to be broken. It's very clear that the city did not want an independent property manager. We've already established that our property manager was already going to be abusive and literally juxtaposes the relationship between principal and agent. The owner is the principal, property manager is the agent. The way corrupt Bradstreet had written this order, and it was written by the city, and this is why the original Judge Umer had said, this type of order would put any reasonable person out of business. He knew it. He wrote it only in March. And yet corrupt Bradstreet a few months later was now trying to say this order is all kosher and everything is good. When the city put forward their motion to enforce the injunction, they knew that they were not acting in good faith. They knew that there is a mechanism for enforcing an injunction. So first, we talked a little bit about the enforcement of judgment law. And they know that most people, and I have a feeling maybe the city didn't know the answer, but they knew well enough that they had already gone to court in front of corrupt Bradstreet twice, seeking to enforce the injunction. And they knew that the method of what they were seeking is contempt order. So when they couldn't get anything from corrupt Bradstreet, they decided to go to the new judge in 501 to try a different hand. When they went in front of Judge Haynes, they then devised a system where they did not even tell him that they actually needed to seek what's called a contempt. The reason why this is important is because the way enforcement of judgment law is written is it has 4 sections. The first thing is it says, in 1982, the state of California realized that they had codes specific to judgments that were spread out everywhere. And that was making it difficult for people to stay organized and to also for the judges to actually apply the law correctly, because you might pull something from a wrong section. So thankfully, in 1982, they got together and actually revamped the entire enforcement of judgment law, and they created what they can now call the EJL. The beauty of the EJL is it's broken down into 4 sections. The 4th category, which is what we're looking at here, and specifically, thankfully, the section says any other judgment outside of those 3 categories can only be enforced through seeking an order from the court for contempt. Meaning, they don't come in and try to take your buildings from you. They go to court and they say this person is behaving improperly, and maybe the court will throw you in jail and tell you to behave, or maybe the court will make other additional orders. But the process of getting a contempt, because it has 2 types of elements, is very risky in the sense that it involves either a civil contempt or a criminal contempt. Because of the protections of your due process in that, they have to actually serve you a new notice to bring you into the case. And when they bring you into the case, they issue what's called an order to show cause, why the judge should not assume that he has jurisdiction over you to do what he needs to do next, which might be throw you in jail because you're violating an order. They didn't do that. And they knew that they might not get that because the standard is very high. So what they did was they just created an order, and they tricked everyone and created I think it's like 20-page receiver appointment order, and said, oh, here's the order, Your Honor, sign it. And the new judge signed it and appointed a receiver. A receiver is a very different animal from a property manager.
If I recall, to conduct an owner movement eviction of a tenant from a unit on 18th Street. She chose the unit, and he was digging his heels in and wanting money, demands of money, and so forth. And I knew since it was a no-cause eviction, eventually he would have to move out. But I reviewed the papers, and there's some sort of defect in it. And under the then law, which changed this year, that the tenants could drag on demurs that attack the pleadings because there's something wrong with the notice. So I pointed that out to Ms. Kihagi and told her the best way to do it is to cure the defect and start all over.
A receiver is an agent of the court, and he's assumed to have the power to take possession of your building. So that's a completely different thing, a receiver order. Through this receiver order of July 29, 2019, they used the receiver to try to to purportedly sell every building. And we'll go through each one of the buildings. So the same receiver sold my building on Filbert. Can't sell it because there was no, the bank in that particular case was claiming that because the city had put a lien on the building before we got the insurance, they were claiming that, oh, we can use, our rents are in jeopardy. There's something called an assignment of rent. Oh, there's jeopardy, we don't know what to do. And then the court said, yeah, no, They came to court, and there was a very smart judge who was not really a regular judge in San Francisco. She was a judge from Marin County. And she said, well, in the interim, while Ms. Kihagi is trying to get a bond, we're not going to allow her to collect the rents because we don't want the city to say she's collecting the rents while the city should be collecting them because they have a money judgment. But you can have a receiver collect on your behalf. So they said, oh, we just need a receiver so we can collect our rents until she gets her bond situation. Well, we got the bond by May 2018. So in other words, then the judge on May 28th or somewhere around June 2018 entered an order saying we're extinguishing all the liens that the city had been trying to file. They had been filing in every county in California their judgment lien to kind of like cloud all your property so you couldn't do anything, so your hands are tied. And they knew what they were doing. Interestingly, after doing what they did, they actually never even removed the liens after we bought a bond. And the law under bond says they're required to remove the liens on your property because you've already bonded. They're going to get the money from the insurance company. But they knew what the law was, but my side did not know the law. And they continued to leave those liens on the property as clouds on title, meaning that no lender would lend you money. That goes into the type of misconduct that we're talking about here. So we've already talked about the judicial misconduct by Deputy City Attorney Michael Weiss, the deputy attorneys that allowed perjury. We've talked about the judge, biased judge, corrupt judge who violated the general canons of being a judge. And now we're after they've gotten all this money, almost $7 million, and they're still seeking more blood. And then Michael Weiss writes a declaration to the court and says, there's an order asking what do we do with her buildings? And the city writes a declaration and says, oh, you can sell them to anybody as long as she does not own them. That's illegal. And he writes a declaration with no shame of letting the world know what the city is thinking. A judge seeing that coming from a city attorney's office would assume the city attorney knows the law and is actually putting forth a position that's supported by the law. And this now comes back into something that's actually interesting. Rule 3.3, professional rule of candor, rule 3.3. And essentially it has two elements, and it's got adopted in California, and it's part of the requirements of any attorney practicing in the state of California. The first part of rule 3.3a, it says, a lawyer shall not knowingly make a false statement of fact or law to the tribunal, or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. 2. A lawyer shall not fail to disclose to the tribunal legal authority in the controlling jurisdiction known to the lawyer to be directly adverse to the position of the client and not disclosed by the opposing counsel, or knowingly misquote to the tribunal the language of a book, statute, decision, or any other legal authority. 3. A lawyer shall not offer evidence that the lawyer knows to be false. If the lawyer's client or a witness called by the lawyer has offered material evidence and the lawyer comes to know of the falsity, the lawyer shall take reasonable remedy measures, including, if necessary, disclosure to the tribunal, unless disclosure is prohibited under Rule 6068. A lawyer may refuse to offer any evidence other than the testimony of a defendant in criminal trial that the lawyer reasonably believes is false. Now this is important because we said in the trial, Michael Weiss was representing that I did not live in my building on 18th Street, yet he had his own main chief witness, Alison Dushevsky, who walked around the buildings and was emailing him almost every day that, oh yeah, these people are blocking the driveway, which is my building. I have a right to block my driveway. And in fact, the city had sent their own investigators to come and actually investigate my open houses to make sure that, oh yeah, not trying to rent units that I had said I'm going to live in. And he wrote an email to some of the tenants, in this case, Jamie Austin and Ray Schreiber and a group of people. And he said, oh no, the unit that Ms. Kihagi has advertised on Craigslist is not the same unit. So, let's relax. That's not it. But yet he offered that evidence in trial as though that evidence that I had advertised on Craigslist meant that I was advertising the unit that I said I was going to live in. And he allowed corrupt Bradstreet to rely on that evidence to the tune where she actually came up with almost like a $70,000 penalty. So this is the kind of thing. First, he had a duty to produce the discovery. 2, he never did. 3, Ms. Uchiyama, the attorney, found the evidence through some other means in a different case with a tenant, where the tenant's attorney produced everything. And so when I found this out, I wrote the city attorney office a total of 29 letters for everything they had misrepresented to the court, And we can go through each one of those things. And essentially what the city had done was misrepresented to the court about the evidence, misrepresented to the court about the change of venue. So I know you asked earlier, why did your attorneys not seek to have corrupt Bradstreet removed? Well, we did. And in fact, Attorney Greg de la Peña filed a motion in which he told the court that based on the fact that the city had put out close to 47 press releases, the court had a duty to absolutely, under CCP, under Code of Civil Procedure Section 394, mandatorily remove the case from San Francisco and find a neutral ground. And then the judge came back and said, in her order, which we're going to go into depth, she said that the claims the city was raising, the claims raised by the city were mostly claims that did not require a jury except for one part, which was the punitive damages. And she said based on that, she didn't feel that there was a duty to recuse the case. Well, actually, the law is different from that. There's case law from the California Supreme Court that says if any one part of the case would be a basis to actually move the case, you don't have to look at the rest of the case. You look at the one reason that you have to move the case, or if it's one individual, and then you move it. There's another reason why that motion by Greg de la Peña was important. He was saying these people have no friends in this case. The city has monetary reasons to try to extract as much money from them. This is not a fair venue because the judge is employed by the city attorneys are employed by the city, and the city has a political agenda that they're trying to enforce. This is not a fair place to have these people's case tried. And corrupt Bradstreet refused not only to recuse herself, but also to allow the case to be moved out of the city of San Francisco. Making her decision, the final order. It's very interesting that she said, I am refusing to allow you to move out of the out of the city, but yet I am deeming you to not live in your building in San Francisco. I don't care where you live, but I know you don't live in San Francisco. In other words, she contradicted herself, and you're not allowed to do that. So when it served corrupt Bradstreet, she could make an order saying, I will not allow you to move your case from San Francisco because we're alleging your sister Julia doesn't live in San Francisco, Christina doesn't live in San Francisco, and you don't live in San Francisco, and that you evicted these tenants or displaced the tenants, saying that you wanted to move into the units, but you didn't move in. And then what happens thereafter is the case then comes forward and it goes into the receiver. And now you have a receiver and you have the judge and the courts now starting to not pay attention to the law, ignoring everything because they're now assuming, oh my God, everything is so negative against these people that the machine, the steamroll is now running. And so the attorney for a bank, very, very greedy law firm that would break any law to make attorney fees. So a lot of motivation by attorneys is always about their money. In this case, an attorney sees the opportunity of another, yet again, black, two female, and two feisty landlord, but he's not paying attention to that part that I'm feisty. And he says maybe she might not be smart enough to figure out this stuff until too late.
So they colluded together to make sure that she never received a dime. And that was also brought up to the court, and he didn't care. He was not acting as the gatekeeper the way a court is supposed to, protecting both parties. They think that might means right, and that you could just railroad somebody, disregard the law, railroad, take away their properties, and tell them to goodbye.
The warrior in me, I don't quit. If I see something I don't like, or if you do something that I don't agree with, I don't quit. And I think what happened was the city thought it was a big, it was like the David and Goliath, that they would literally prejudice the entire press and the city, and no one would ever really pay attention to my story because eventually I would just crumble and go away. Two black, two female, two feisty.